Hi folks, you're with Tacitus Today at your Pushback channel. Thank you for watching, and while you're with us, please take a moment to subscribe below. A significant, if not seminal matter that has received surprisingly little attention, particularly so given the far-reaching ramifications and knock-on effects since the 1960s, and effects we feel increasingly today, has been the Western government abandonment of the core principles of recognising the unambiguous protection of private property. Private property is at the centre of Western democracy: civic participation, codified law, capitalism and due legal process. If any government begins to abandon the laws ensuring and protecting private property, then they are also signalling the abandonment of capitalist rule of law democracy. The two issues are inextricably linked. This essay will examine the changing laws and government attitudes of how private property is defined and protected in the Western democracies. During the 1960s, those fronting the movement to change the Western definition of private property were feminist agitators, with names like Shulamith Firestone, Emma Goldman, Marcia Friedman, Sheila Levine, Betty Friedan, Kate Millett and Hester Eisenstein. They posited that upon divorce, women should be entitled to at least half a man's property and assets. Children should be considered the property of women, plus an added payout bonus to the woman for each child, regardless of whether or not the woman had contributed equally or made any recognisable contribution at all to the property and assets of the marriage. It will come as no surprise that, as well as seeking conditions to ensure duty-less property redistribution, these activist women were deeply committed to the full range of social engineering Marxist socialist principles, with Betty Friedan actually having edited a communist revolutionary newspaper directly funded by the Russian Soviet government. Kate Millett founded a special women's lesbian art colony in New York. Hester Eisenstein is a tenured gender studies academic in the United States. All women were deeply hostile to marriage within any form of patriarchy, as well as capitalism and, of course, families, which was fully consistent with communist revolutionary propaganda of the time. Betty Friedan and Shulamith Firestone both had produced and published propaganda-intensive material which variously referred to marriage as being a caged hell for women, and the whole idea of having children as representing the extreme exploitation of women, or the tapeworm of exploitation, as Shulamith Firestone would say. As the majority of American married women were the most pampered, wealthiest, leisure time rich women in the history of the world, this alleged universality contained within the Femi propaganda caged hell line is patently absurd. California was the favoured launchpad for this new feminist Marxist assault on, or redefinition of, private property due to the California communal property ownership laws that dated from the 1850s gold rush days. In most other states of the US and internationally, residential property was owned by individuals, so the California communal property ownership laws offered unique opportunities for applying Marxist interpretations to property ownership within and following the dissolution of a marriage. The tactics and strategies frontline activists and their backers employed in pursuit of these outcomes went something like this: to have the marriage defined as a communal association, rather like, say, a commercial partnership, and that such definition be applied retrospectively regardless of when the marriage might have begun. Thus, by extension, all assets in the marriage were equally owned by the marriage partners, with minor children also being considered ostensible owners. Simply put, this meant that in the event of a divorce, say a family of four, a husband, wife and two children, each party technically owns 25% of the assets. The divorced man, thus, by application of this definition, now owns only 25% of the 100% he owned the day before. Even if all the other claimants had made no contribution to any of the assets, the definition of the relationship that the Femi agitators proposed made all assets communal, leading of course to equal outcomes. These agitators were very well funded. There was a lot of travelling, a lot of them were moving back and forth between California and New York, a lot of plane flights, a lot of hotel bills, and they were very well funded. So where did all this money come from? So contributions to a marriage would become irrelevant under this arrangement. Non-financial contributions could be arbitrarily valued without regards to any facts. That is, the intent became, once the marriage dissolved, it was to be transformed into an exercise in compensation and compensation law, independent of any actual contribution of material value. This was to usher an entirely new form of ideological jurisprudence that today has, many may say quite destructively, permeated all areas of law. This equating of a marriage, which for anyone other than Hollywood superstars is really quite a low-risk venture, or certainly was at the time, with, say, the assets of a commercial business or business partnership, or a high-risk venture, such as, say, mining exploration, and this is all in terms of who owns what. This was something of quite a serious overstretch. There wasn't that high risk in divorce or marriage dissolution at the time, not for most people. But it was when this communal ownership was added to the natural presumption of maternal child custody that it became state-sanctioned and supported exercise in property theft, which produced rich and guaranteed outcomes for the party that had contributed little or nothing to the marriage. The activist arguments today for, say, black compensation run along very similar lines of Marxist-style logic. A person who has made no contribution to the property could take it from the legal owner with the approval and support of the state. The property owners who disagreed could be fined or even imprisoned. The no-fault divorce law, with the attached provisions for assets and marriage property being deemed communal property, was signed into California law by then first-term Republican Governor Ronald Reagan, who incidentally also signed off on the abortion rights bill in California. Even today, both are considered seminal leftist legislative victories. Interestingly, and part of the material for another video, is Ronald Reagan, as President of the United States, presided over the notable beginning of the upsurge in illegal and some legal, but particularly illegal, immigration from Mexico into the USA and from other third world countries. It all began in earnest during the Reagan presidency. This, coupled with a noted and suddenly acquired reluctance of authorities to deport illegals, all happened at the same time. Perhaps it was all coincidence. Feminist activists and their backers were much less keen to agitate for no-fault divorce in state jurisdictions where division of assets was not communal, but based on actual provable individual contributions, as this would have maintained the integrity of individual property ownership, which these agitators were seeking to usurp. Yet an incredible set of developments. Within a few years of California, all US states had not only followed the California blueprint of no-fault divorce, but also taken up the communal ownership of all marital property and assets, as well as a default presumption of maternal child custody. It was a stunning feminist victory and remains remarkable even by today's standards. Their demands and expectations had not only been met, but wildly exceeded, and had all fallen into place within a few years, not the decades they and their backers had imagined it would likely take. This was to usher in an era unprecedented in the scale of what was effectively state confiscation of property owned by one party, and then having that property transferred to the ownership of another party, where the party from whom the wealth is stolen has committed no actual or inferred crime. And this appropriation is greater in scale even than the appropriation of Jewish wealth in Europe between 1933 and 1945, or the Tudor monarch's appropriation of all church wealth and property in England in the medieval times. Before passing into law, some minimal debate in the various state legislatures in regard to the merits of no-fault divorce and communal ownership of property did take place, particularly amongst the more devout members, but even so, communal ownership of property and assets, as well as default presumption of maternal custody, all of it went through into law with barely a murmur, as if it were just some minimally relevant piece of administration adjustment, and with scant regard to the constitutionality of any of it. It's worth keeping in mind that those politicians at the time voting these measures into law were 95% plus white, heterosexual male family men with their mistresses, their hot little interns, and their assured future careers as well-paid lobbyists or flunkies sitting on the board of some quango or other. In the day, you would have struggled to find even one feminist sympathiser among them, or more than a handful who could have listed any of the feminist demands. Yet it is these men who delivered to feminism perhaps one of their greatest socio-legislative victories in modern history. Clearly, these legislators did not take these steps due to any association or sympathy with feminism. It was done for other reasons and to prepare the path ahead. Within little over a decade, this California model of no-fault divorce and communal property ownership, default maternal child custody, had spread across pretty much the entire Western world. As no other nation held laws, statutes or constitutional provisions for communal ownership, most nation-states turned themselves inside out to establish divorce law in this model and its attendant issues of property seizure as a set of laws sitting outside of the Constitution. During this time and through the 1970s and 80s, we even see the US using international trade agreements as a means to force the US model of divorce and gender-based property seizure laws onto other countries, including threats of reduced access to US markets for non-compliance. It was a supreme effort that was made by the US. Trade agreements were also used by, with hindsight, what may have been what today we would call deep state operatives to force US neo-social laws such as alimony collection onto other nations, which could include arrest, detention and arbitrary property seizure. It's difficult to find any other area of international law that has attracted so much effort and determination to pursue, enforce and standardise through strong-arm provisions within trade agreements across the Western world, other than this divorce and property redistribution and attendant alimony issues. Yet this demonstrates just how important social engineering issues were, and they percolated to the top of priority lists ahead of most, if not all, other issues. It can't be that easy to lean on a sovereign democratic government and just demand they suspend due legal process to seize property and income and to covertly put this in place without the consent of the voters. Moreover, the burden of proof required for a client state to initiate proceedings for, say, international alimony action against any individual was reduced to minimal, if anything at all, and for the most part required only clerk-level administrative action and box-ticking. For the accused, however, any response must be legal, involving a full court hearing. Any other crime or misdemeanour, including major crimes, requires a full court hearing with a clear burden of proof before any action can be taken. Only social engineering laws enacted and enforced by the state require a low or zero burden of proof. The jurisprudential approach directly and strangely insisted on by the US within their international trade agreements of that Ronald Reagan era. Drug lords and those accused of multiple homicides had more rights than this. Yet these discreetly placed and barely noticed legal changes, which all began in the US and then radiated outward across the Western world, were all part of the building blocks of what we would call today creeping globalization. As with any set of laws and attendant punishments that are inherently unjust, a government-funded moral panic propaganda campaign is rolled out as cover and to justify laws that seem harsh with a confusing yet rather suspicious ulterior motive. A quick overview of the media stories dating from, say, the 70s onwards, starting in the US and spreading outward from there through the 80s and 90s, show a sudden surge in stories claiming marriage to be a violent institution that oppressed women. As the marriage contract disappeared, so too did the legal standing of property ownership. Wife-battering, child-abusing husbands, so the propaganda claimed, were in every closet under every bed. Divorcing women were not just out to grab a free house, guaranteed ownership of children, or an ongoing tax-free alimony income, because they so very easily could, but instead, so the propaganda claimed, they were escaping the suddenly invented legions of violent, abusive, wife-battering husbands. The amount and shrill tone of propaganda is always in direct proportion to the scale of the debasement it seeks to conceal or obfuscate. Such morally bad men, which was almost all married men, according to the propaganda, it seems, did not deserve legal rights. They were that bad. And if they lost their property and also their income for many years to come, they were just getting what was coming to them. It was moral justice. So the public were duped into believing. Reminds me of a few things going on today. So let's fast forward to today. Whites are evil, wicked, supremacist, fascist, colonialists who should be sacrificing their property and paying a duty-less compensation to just about every brown and black person on the planet. Today we are being told that is now a new frontier of moral justice. Whether we see all this arbitrary law as the road to hell being paved with some misguided good intentions, or a series of severely misguided acts where one begets another and then another, or is it part of a wider social engineering, deep state, early globalization plan? It's difficult to say. Could globalization have occurred without first redefining marriage and private property and, of course, national identity? Probably not. You've been with Tacitus Today at your Pushback channel. Thank you for watching, and we hope you found this essay informative. Please remember our essays are available in printed softcover book or ebook format. So choose any of our essays and please order at the email address below. Thank you.